Welcome to the next episode of Small Business Legal Tips. I'm attorney Mark Bross of Bross Law LLC. I'm a practicing Massachusetts business lawyer with over 15 years of experience helping entrepreneurs start a business. Today, we're going to talk about legal issues you need to resolve when starting up an e-commerce business, especially in Massachusetts. E-commerce businesses come in all shapes and sizes, and you might be thinking about selling physical goods, digital goods, services, or lots of other things. No matter what you're selling, though, there are quite a few legal issues that need to be handled. Today, we're going to talk about 7 key ones: business structures, sales taxes, data security and privacy, consumer protection, terms of use, and local licensing and zoning. Each one is important, and you want to be sure to solve all of them before launching your e-commerce business in Massachusetts. And if you'd like to get more helpful legal tips, please hit the like and subscribe button. It really helps the channel and lets me know you'd like to receive more helpful legal tips like this one. So let's get to it. One of the first things you want to consider when starting up your e-commerce business in Massachusetts is what type of legal structure you're going to operate the business under. And there are really 3 main options: sole proprietorship, corporation, or limited liability company, also called an LLC. Each of these structures have their advantages and disadvantages, and which one you choose depends on your personal preferences and your personal and financial circumstances. Let's start with a sole proprietorship. A sole proprietorship is the most basic form because it's not really a business structure at all. It's just one person operating a business under their own name or some other name they've chosen. For example, if your name is Bob Smith and you're offering business consulting services, you might want to operate under the name Bob Smith Business Consulting or Premier Business Consulting or something like that. The benefit of a sole proprietorship is that it's easy and cheap to set up. You just need to buy a website, set it up, and take whatever other required steps are needed to launch a consulting business. It's that easy. Note that if you're operating under a name that's not your own personal name, such as Premier Business Consulting, you'll need to obtain a business certificate in the town or city where you're located, which we'll talk more about later. The drawback to a sole proprietorship is that it provides absolutely no liability protection for any other personal asset you have, and they are at risk by the operations of your e-commerce store. A corporation, on the other hand, does provide liability protection for your other personal assets so long as it's set up properly and you follow all the rules associated with the corporation. I've talked more about corporations in some earlier videos, so I won't go into all the details here. I'll put a link to the videos below. Generally speaking, though, to set up a corporation, you need to file articles of organization with the Massachusetts Division of Corporations, pay the filing fees of at least $265, adopt bylaws, elect officers and directors, issue shares, and take various other steps. The upside to a corporation is that it provides liability protection for your other personal assets, and there are well-developed rules for the responsibilities of the officers and directors in your corporation. The downside to a corporation is that there are a lot of rules to follow. And if you don't follow all of them, you run the risk of your corporate form being ignored, which is called piercing the corporate veil, and being held personally liable, which is what you're trying to avoid by setting up a corporation in the first place. An LLC is meant to solve some of these downsides of the corporation. It also provides personal liability protection for your other personal assets, but has less rules to follow than a corporation. But a downside is that it still has some rules to follow and can be a little more expensive to operate in Massachusetts. I talked more about LLCs in some other videos, and I won't go into all the details again here. I'll just put a link to the videos below. Apart from liability protection, though, the other major benefit of an LLC is that it's a very flexible entity, and you can choose how the entity is going to be taxed and how it's going to be managed. This flexibility is really appealing to a lot of people, and it's one of the major reasons why an LLC has become the most popular entity for e-commerce businesses. The biggest drawback is the expense, especially since you often need a very detailed operating agreement and the filing fees of the Massachusetts Division of Corporations, which are at least $520 that have to be paid each and every year. So you might be wondering, what entity should you choose for your Massachusetts e-commerce business? And there really is no one right answer. It just depends on what you prefer and your personal financial and business situation. However, if you can afford to, I would highly recommend setting up an LLC or a corporation in connection with your e-commerce business. No matter what you're selling, you're potentially selling to people all over the United States or over the world, and it's better to have as much protection as you can for your other personal assets. Sole proprietorships provide absolutely no protection for your other personal assets and they're always at risk from the operations of the e-commerce business if you operate as a sole proprietorship. However, keep in mind that no matter what entity you choose, the personal asset shielding protection is not absolute. As I've discussed in some earlier videos, there are various ways that the corporate veil can get pierced for both corporations and LLCs, and you can still be found personally liable. I'll put a link to the videos below. The next legal issue to resolve before launching your e-commerce business in Massachusetts is sales tax collection. As an e-commerce business located in Massachusetts, you're most likely going to have to collect Massachusetts sales tax in connection with each and every sale. Massachusetts applies a statewide sales tax of 6.25% on most retail sales of tangible personal property and certain services. This includes things like electronics, furniture, appliances, clothing over $175, jewelry, and most digital goods such as downloaded music, movies, books, and software. Some services are also taxed, such as telecommunication services, installation services, a software service, and various other types. Speak with an accountant if you're not sure whether your goods or services are subject to Massachusetts sales tax. If your e-commerce goods or services are subject to sales tax, you'll be required to do a couple of things. First, you'll need to obtain a federal employer identification number, also called an EIN, from the Internal Revenue Service, also called the IRS. This is a pretty straightforward process and can be done online with the IRS. I'll put a link to the website below. After you obtain the EIN, you'll need to register to collect sales and use tax with the Massachusetts Department of Revenue, also called the DOR, through Mass Tax Connect. I'll put a link to the website below. After you obtain the sales and use tax registration certificate, which is Form ST-1, you'll need to display it prominently at your business location. For an e-commerce business, that will mean your primary office area. After you've registered to collect sales tax, you'll need to actually collect it with each sale and timely submit payments and returns to the Mass DOR. The date you need to pay the Mass DOR will depend on how much you collect, but it can be monthly, quarterly, or annually. I'll put a link to the Mass DOR website below that contains helpful information about the deadlines for filing your tax returns and remitting payment to the Mass DOR. Speak with an accountant if you have any questions. Don't ignore making timely payments to the Mass DOR. The Massachusetts DOR will audit you to make sure they get paid in the right amounts and at the right time. And you really don't want the Mass DOR coming after you. In addition to collecting Massachusetts sales tax, you may also be required to collect and remit sales tax to other states. It all depends on whether your e-commerce business has what is called a, quote, economic nexus, end quote, with the state. The concept of economic nexus comes from a 2018 Supreme Court case, South Dakota versus Wayfair, where the court found that states could force out-of-state e-commerce retailers to collect and remit sales tax, so long as the e-commerce retailer conducts enough business in the state. So what does that mean for your Massachusetts e-commerce business? Economic nexus is triggered when your e-commerce business crosses a state's defined threshold for sales revenue or transaction volume in the state. For some time after Wayfair, the threshold for many states was $100,000 in sales revenue in the state or 200 transactions in the state. However, the threshold of 200 transactions in a state has now been mostly eliminated in most states, with nearly all states focusing solely on a defined revenue threshold. Some larger states, like California or Texas, have a single threshold of $500,000 in revenue in the state before the economic nexus threshold is triggered. But it really will vary from state to state, and you need to comply with each state's threshold where you sell your goods and services. State revenue and tax departments are actively monitoring this within the state, and if your business crosses an economic nexus threshold and fails to register and collect taxes in the state, you could be held liable for all back taxes, penalties, and interest. Nobody wants that. Now, when you're just starting up your e-commerce business in Massachusetts, you're probably not too worried about collecting sales tax for other states because you don't have any revenue yet. But you really should start planning for it now and make use of software like Avalara or TaxJar or anything else to keep track of your sales activity in each and every state. And as soon as you hit the economic nexus threshold in a state, you should register for a sales tax permit with the state's Department of Revenue before collecting any tax. It is illegal to collect sales tax in a state without a permit. After you're registered to collect sales tax with any other state, collect the sales tax and timely file your returns with each state. Automation can really be helpful here, and some platforms like Shopify offer tools to help with this. Use them as needed to ensure that you're complying with your tax obligation. You really don't want to mess with the tax authority of any state since they usually have the ability to attach and freeze all sorts of assets. The next important legal issue for your e-commerce business is one that's often the most overlooked: data security and privacy. Massachusetts became one of the state pioneers in data privacy when it passed MGL Chapter 93H and issued 201 CMR 17, which is a regulation called the Standard for the Protection of Personal Information of Residents of the Commonwealth. This regulation applies to any business that owns or licenses the personal information of a Massachusetts resident. For an e-commerce business, this includes the collection of a customer name in combination with any one of the following: financial account information, credit or debit card information, driver's license number, or a social security number. If you collect this information, your business is required to develop and implement a written information security program, which is also called a WISP. A WISP must outline the administrative, technical, and physical safeguards that your e-commerce business has put in place to protect the personal information of Massachusetts residents. At a bare minimum, to comply with the law, your WISP should identify and put in place the following safeguards that are identified on the screen. If you don't comply with these requirements and your business is unlucky enough to have a data breach, the fines can be significant. In a recent enforcement action, the Massachusetts Attorney General fined the online retailer Bombas LLC $85,000 after it suffered a data breach incident that involved more than 1,000 Massachusetts residents. Bombas sold socks online, and the Attorney General alleged that Bombas didn't have a WISP or implement the appropriate safeguards to protect the credit card information of Massachusetts residents. Along with the fine, Bombas will be required to have a WISP and have annual third-party audits for several years to ensure compliance with all legally required data security practices. You really don't want to have a data breach or be investigated by the Massachusetts Attorney General. So it's far better to be proactive here and take the necessary steps to comply with the law by having a WISP and implementing the administrative, technical, and physical safeguards that are needed to protect the personal information of Massachusetts residents. Aside from a WISP, the other important privacy and data security document that you want to have for your e-commerce business is a privacy policy. Although Massachusetts doesn't require a privacy policy for your website, many states do, such as California or the European Union if you're selling internationally. Also, your e-commerce business will be required to have one if you plan on doing any advertising on Facebook or Google Ads, or if you have a mobile app that's going to be downloaded on an app store, such as the Apple App Store. Be very careful when drafting your privacy policy and don't just download one from some other website. These other privacy policies might not be appropriate for your e-commerce business or reflect your actual privacy and data practices. Generally speaking, your privacy policies should provide accurate and clear answers to the following questions. First, what information does your e-commerce business collect from anyone who visits your website or purchases goods and services from your e-commerce business? Be as specific and accurate as possible. General categories of information such as website browsers, location, names, email addresses, or phone numbers are fine so long as your business actually collects that information. Second, what does your e-commerce business do with the information that is collected? Make sure to disclose everything that your Massachusetts business does with the information that you collect. For example, your privacy policy should definitely say that your e-commerce business uses the information it collects to improve its website or app, fulfill each customer's order, or communicate with customers regarding its order. But if your e-commerce business also uses the information for email marketing or text message marketing, you also want to disclose that in your privacy policy. Err on the side of overdisclosure here and disclose every possible use of the personal information that your business is going to do, along with the reasons why your business is using that information in that way. Third, where does your e-commerce business keep the information it collects, and how do you protect it? Be as specific and accurate as you can. For example, if you use Amazon Web Services to store your data, make sure to disclose that and put a link to the AWS website that explains what Amazon does with the information that's stored on their service. And with respect to how your e-commerce business is protecting the data it collects, make sure to accurately state what you are doing to protect it. Be consistent with your WIP if you have one, and don't overstate what your business is actually doing to protect any information you collect. For example, don't state that your business encrypts all information that's stored on its servers unless that's actually what you're going to do. The biggest risk here is that your business promises to do something to protect your customers' personal information, but hasn't followed through on the promise. Fourth, who does your Massachusetts e-commerce business share the information it collects with, And do you sell it to anyone? Make sure to disclose any third-party vendors your business uses in connection with your website or app, marketing efforts, or information storage. For example, if you use Google Analytics to monitor your website, which most websites do, that should be disclosed in your privacy policies. Like possible uses of the information you collect, you should disclose as much as you reasonably can to make it clear who your e-commerce business is sharing the information it collects with. In addition to these clauses, there are lots of other things that should go into a privacy policy that are far beyond the scope of this video. Speak with a knowledgeable attorney if you have any questions. However, the most important thing to keep in mind is that the privacy policy for your Massachusetts e-commerce business must be accurate and not misleading. Otherwise, you run the risk of violating the Massachusetts Consumer Protection Statute, which we'll talk about next. The next important legal consideration for your Massachusetts e-commerce business is the Massachusetts Consumer Protection Act, which is MGL Chapter 93A, usually just called 93A. 93A prohibits unfair or deceptive trade practices in Massachusetts and can be enforced by the Massachusetts Attorney General or by individual consumers. Any violation of your privacy policy can be arguably considered a violation of 93A because you're misrepresenting the privacy practices of your business, and that's deceptive. For 93A violations, a plaintiff can recover their attorney's fees and possibly double or treble damages. No business wants that, so make sure that your privacy policies are as accurate as possible. Additionally, starting in 2025, the Massachusetts Attorney General issued Regulation 940 CMR 38 that prohibits what are called, quote, junk fees, end quote. Junk fees are hidden, surprise, or unnecessary costs that increase the cost of what consumers have to pay for your goods or services. This can include things like credit card processing fees, assembly fees, affiliated goods fees, and similar items. These regulations specifically apply to e-commerce businesses, so you want to make sure to comply with the junk fee regulations. Failing to comply is an automatic 93A violation and can lead to penalties of up to $5,000 per violation, and consumer can pursue all other 93A damages, including double or treble damages and attorney's fees. So what needs to be done by your e-commerce business to comply with the junk fee regulations? As with many regulations, there are a lot of things that need to be done in order to comply. Here are some of the most important things you need to do. First, your e-commerce business must prominently display the total price of the goods and services that are being purchased. The total price of a product is a defined term and means, quote, the maximum price a consumer must pay for a product inclusive of all fees, charges, or other expenses, end quote. This price must be prominently displayed on your website or app before the consumer makes the purchase or provides you with any kind of personal information. So if you charge a processing fee in connection with the transaction, this must be disclosed upfront to the potential consumer before the consumer agrees to purchase the goods or services. Second, your e-commerce business must disclose the nature, purpose, and amount of any fees that you charge and why you charge them. For fees that are optional or waivable, your business must disclose the fact that the fee is optional and provide the consumer with explicit instructions about how to avoid paying the fees. Keep in mind that this disclosure requirement only applies if you break out fees separately and explicitly. If your total price is an all-in-one price that includes all fees and expenses, you are not required to break them down to the consumer. But if you do break out some components as additional fees or expenses, you'll need to explain which ones are optional and how the consumer can avoid paying them. Third, if your e-commerce business offers trial offers or subscriptions, there are very detailed requirements that must be met to comply with the junk fee regulations. Most importantly, your business must clearly and conspicuously disclose that the consumer will be charged at the end of the trial period and that these charges will occur on a recurring basis. Also, your e-commerce business must provide the customer with a simple mechanism to cancel or avoid any recurring charge and provide the consumers with at least 5 days notice before they will be charged. There are lots of other nuances and requirements to the junk fee regulations, and complying with it can be difficult. I'll put a link to the junk fee regulations below. If you have any questions, make sure to speak with a knowledgeable attorney before your e-commerce business is launched in Massachusetts. The next important legal consideration for your e-commerce business is the terms of use or terms of service for your website or your mobile app. Your terms of use are intended to be a legally binding contract between your business and every person who visits or buys from your website or through your mobile app. Most people think of terms of use as unimportant legal boilerplate included at the bottom of your website or on a separate page that nobody ever reads. And they're probably right that almost nobody ever reads the terms of use for your website or your app. However, so long as the terms are enforceable, which we'll talk about in a moment, the terms of use are essential for protecting your business. Here are some key clauses you want to include in the terms of use for your Massachusetts e-commerce business. First, you want to have a preamble or an opening section at the very top of the terms of use that states that these terms of use govern the use of the website or the mobile app and any orders that are placed with your business. This preamble should also specifically identify the website or the app name and your business name and state that the business owns the website and all the content on the website or in the mobile app. For example, suppose you're operating an e-commerce pet store called CocoPetSupplies.com after my dog Coco, and you're operating through an LLC called Coco Pet Supplies LLC. Then the preamble for the terms of use should state that CocoPetSupply.com is owned by Coco Pet Supplies LLC, and that any orders placed through CocoPetSupply.com are governed by these terms of use. Second, the terms of use for your e-commerce business should also have an explicit section governing shipments, delivery, and risk of loss. This is critical for any Massachusetts e-commerce business that's shipping its products all over the country or the world. The purpose of this section is to lay out how shipping and handling will be processed and should include disclaimers that the risk of loss passes to the customers after the products are shipped. That way, if the products are damaged during transport, you're not held responsible. Also, if you're a drop shipper, this section should specifically state that some third party is actually responsible for supplying and shipping the goods to any customer. Be as specific as you're comfortable with in order to protect yourself in case there are problems with a missed or delayed shipment. For example, if your third-party supplier fails to ship an order to a customer even though it was properly placed, you want to be able to rely on your terms of use to protect you when explaining the problem. Third, the terms of use for your Massachusetts e-commerce business should also have a section for returns and refunds. This section should clearly state your refund policy and whether you offer a refund or not. If you don't offer a refund under any circumstances, you need to state that here. And if you do offer a refund, this section should explain how your customer can obtain a refund, how long they have to request a refund, and who is responsible for return shipping costs. Again, be as specific and detailed as possible. Fourth, the terms of use for your e-commerce business should also have a disclaimer of warranty section. The purpose of this section is to tell your customers what you are not promising or guaranteeing about the products or services that you're selling. In this section, you want to be sure to state that you're providing the products or services, quote, as is, end quote, and, quote, with all faults, end quote. You also want to specifically disclaim the warranty for a particular purpose, merchantability, and several other warranties that are implied by law. Also, if your Massachusetts e-commerce business is selling someone else's products and they offer a warranty, this section should specifically reference the third-party manufacturer's warranty and say that you are not responsible for the manufacturer's warranty or any product defect. Speak with an attorney if you have any questions. Disclaimers of warranties can be very tricky, and you don't want to make any mistakes. Fifth, the terms of use for your e-commerce store should also have a limitation on liability section. The purpose of this section is to limit your liability in case something goes wrong. As part of this section, you want to make sure and state that the customer is assuming all risk in connection with using the goods or services purchased from your e-commerce business. Also, you want to include an aggregate cap on your liability, which is often the amount that the customer spent on the goods or services from your business in the past year. Massachusetts courts do enforce limitation of liability clauses so long as they don't violate Chapter 93A or are otherwise considered unfair or deceptive. So, if you violate the junk rule regulations we discussed earlier or lie in your privacy policy, and these breaches lead to customer damages, you won't be able to rely on your limitation of liability section to protect you. Speak with an attorney if you have any questions or if you need help in drafting your limitation of liability section. Sixth, the terms of use for your e-commerce store should also include a Massachusetts choice of law and choice of forum clause. The Massachusetts Choice of Law Clause ensures that your website and the goods and services you're providing are governed by Massachusetts law and not the laws of some other state. This is really important because states vary drastically and you don't want to be governed by some other state's law since you're a Massachusetts e-commerce business. Related to this, a Massachusetts Choice of Forum will require that any disputes related to your e-commerce business or the goods and services you provide will be brought in Massachusetts. Without this, a customer in California could drag you into a court in their home state, which means you'd have to fly across the country to defend yourself. With a forum selection clause, you're forcing all disputes to be brought in Massachusetts courts where your business actually operates, and it's easier for you to defend yourself. The language for a forum selection clause is reasonably straightforward. It should say something like, quote, any disputes arising out of or relating to these terms of use or the goods and services delivered shall be resolved exclusively in the state or federal courts located in the Commonwealth of Massachusetts, end quote. And if you prefer arbitration, you could also specify arbitration in Massachusetts, but the clause would need to be much more detailed and specific. Speak with a knowledgeable attorney if you need help in drafting a forum selection clause, especially an arbitration clause. There are lots of other clauses that should be included in a strong terms of use for your Massachusetts e-commerce business. If you have any questions, I highly recommend you speak with a knowledgeable business attorney. However, no matter what clauses you include in your terms of use, the most important thing is to make sure that the terms are enforceable. Enforcing terms of use in an e-commerce situation requires a valid contract, which Massachusetts courts analyze under a two-pronged test: reasonable notice and reasonable manifestation of assent. The 2021 Massachusetts Supreme Judicial Court decision, Cotters versus Uber Technologies, Inc., remains the baseline in Massachusetts for enforcing website terms of use. In that case, the SJC held that click-wrap website agreements, which are where a user must affirmatively check a box stating, I agree to the terms of use, are the preferred method for ensuring enforceability. In contrast, browser wrap interfaces that merely state, quote, by signing up, you agree to our website terms of use, end quote, are increasingly found to be insufficient, particularly if the hyperlink to the terms of use is obscured. So, in order to make sure that the terms of use for your e-commerce business are enforceable, make sure that the consumer has to check a box when placing the order or reaching out to you that says, I agree to the terms of use in your website or your app. The next important legal consideration for your Massachusetts e-commerce business is local licensing and permits. You might be surprised by this, since your e-commerce store will be selling over the internet or by mobile app, and you won't actually have a physical store in the Commonwealth of Massachusetts. But to the extent you're operating your e-commerce business out of a location in Massachusetts, such as your home, you'll still need to comply with the local laws in the town where you're located. And there are really three main areas to focus on. The first is the business certificate, also known as the DBA certificate. Under MGL Chapter 110, Section 5, any person or entity conducting business under a name other than their legal name must file a business certificate. If you're operating out of Hingham, for example, you must file the business certificate with the Hingham Town Clerk. The fee is $50, and the business certificate is valid for 4 years. If you're filing in the city of Boston, though, you must file the certificate with City Hall, and the cost will be at least $65, although it can be higher if you're not a resident of Massachusetts. Failure to file the business certificate can result in a fine of up to $300 for every month you're in violation. Second, you need to comply with local zoning ordinances. In many instances, this requirement gets overlooked. But you don't want to unwind your new e-commerce business because you failed to take the proper steps at the beginning. Many Massachusetts municipalities distinguish between a home occupation, which is typically allowed by right, and a home business, which may require a special permit from the Zoning Board of Appeals. In many Massachusetts towns, your business must remain, quote, clearly incidental and secondary, end quote, to the residential use of the home in order for the business to be allowed. Make sure to check with your local municipality to find out if your e-commerce business can operate in the specific zoning district where your house or office is located. Third, depending on what your e-commerce business is selling, you may also need other licenses or permits. The licenses or permits needed will depend on the kind of e-commerce business you plan on operating, and certain e-commerce businesses may also require federal, state, or municipal licenses. So it's imperative that you check all three resources before opening your e-commerce business. For example, in certain cases, such as selling food online, your e-commerce business may also be required to obtain an inspection from the local health department. Sign permits may also be required in some cases and in some municipalities. Speak with a knowledgeable attorney if you have any questions about local permits and licenses needed for your e-commerce business. However, I highly recommend you reach out to your local town hall because they're usually very helpful and want to help you set up a business. To summarize, here are 6 essential legal issues to resolve before opening your e-commerce business in Massachusetts. Number 1, determine the right business structure for your Massachusetts e-commerce business. Number 2, register for Massachusetts sales tax collection with the Massachusetts DOR and prepare for how other states are going to be handled. Number 3, create a WISP and a privacy policy that will reflect the actual data and privacy practices of your e-commerce business and implement all necessary safeguards. Number 4, comply with Massachusetts 93A and the junk fee regulations. Number 5, create a robust terms of use for your website or app that protects your e-commerce business. Number 6, find out what local licenses and permits are needed for your e-commerce business and apply for and obtain for whatever ones you need. And make sure that your e-commerce business is allowed by any local zoning, especially if it's a home-based e-commerce business. I know that this seems like a lot, and that the legal burden for operating a business in Massachusetts is high, but you can do this, and lots of people have done it successfully. If you have any questions, please feel free to reach out to me before launching your e-commerce business in Massachusetts. I'm here to help you navigate the law so you can focus on building and growing your business. I hope you found this information helpful. If you found it helpful, please hit the like and subscribe button and share it with another Massachusetts entrepreneur who is starting up an e-commerce business. Thank you so much for watching, and I'll see you on the next episode of Small Business Legal Tips.